Hello everyone, welcome to the 140 Literary and Jury Charge. We're going to start off with some legal opinion. All right, here we go. Ready? The plaintiff sought damages in 2 counts from defendant Community Hospital for injuries allegedly sustained when she slipped and fell in the hospital lobby after being discharged as a patient from the hospital after the jury failed to reach a verdict on count 2. The trial court entered a directed verdict for defendant and then entered judgment on the verdict. Plaintiff appeals from that judgment, contending that as to count 2, she presented sufficient evidence to withstand a motion for a direct verdict. Count 1 of the complaint alleged premises liability. The trial court directed a verdict in favor of the defendant as to count 1 at the close of all the evidence, and plaintiff does not appeal from that judgment. Count 2 alleges negligence, that defendant breached the standard of accepted care in the manner of discharging the plaintiff, and that plaintiff's acts or omissions proximately caused plaintiff's fall and injuries. Prior to trial, pursuant to Supreme Court Rule 220, defendant served plaintiff interrogatories regarding any experts whom plaintiff might call. Plaintiff did not respond to the interrogatories. When the trial began, plaintiff stated that she had no expert witnesses. At trial, plaintiff testified that on June 4, 2011, she was discharged from the hospital following an operation which had been performed 9 days earlier. That morning, plaintiff had taken pain medication prescribed by Dr. Kelly. Plaintiff received no information about discharge procedures. From her room, plaintiff signaled the nurse that she was dressed and ready to leave. The nurse told her to come to the nurse's station, which plaintiff did, carrying her bag. Plaintiff testified that she inched her way toward the nurse's station, slipping and sliding due to her pain. Her difficulty would be obvious to anyone observing her, as it took approximately 20 minutes to get down the hallway. The attending nurse then told plaintiff that she should leave. In the elevator, plaintiff felt sweaty, dizzy, and nauseous. As she walked toward the hospital entrance, plaintiff slipped and fell. Plaintiff testified that the floor was slick and a carpet buckled where it was taped down, but she was not sure what caused her to fall. She was subsequently admitted to a different hospital for alleged injuries to her back and legs. Plaintiff then tendered Dr. John Kelly, her treating physician, as her intended expert on standard of care and questions. Defendant objected because of plaintiff's failure to identify Dr. Kelly as an expert pursuant to Supreme Court Rule 220. The court ruled that Dr. Kelly's testimony would be limited to questions concerning his actual care and treatment of plaintiff. Dr. Kelly testified that plaintiff had a normal recovery from surgery and that he considered her progress in walking to be normal. He saw plaintiff prior to discharge and found she had no problem walking. Plaintiff was given no pain medication on the day of her discharge, although she did receive a vitamin. The medications which plaintiff received on the previous day would not affect her ability to walk or her sensory abilities the following day. In regard to plaintiff's discharge, Dr. Kelly testified that plaintiff stated her husband could not pick her up until later in the day, and Dr. Kelly indicated that this would be no problem. Dr. Kelly informed the attending nurses that plaintiff would be leaving sometime later in the day. Dr. Kelly stated further that he had no knowledge of how patients leave the hospital, specifically on a specific patient. It was Dr. Kelly's understanding that the normal course would be that somebody would accompany the patient to the first floor or to the car. That was his understanding and has been his experience. When asked if he was familiar with defendant's discharge policies, Dr. Kelly replied, "The specific policies, no, but the normal policy that somebody would accompany a patient, yes, I am familiar with that policy, but I haven't studied the book of policies." At the close of plaintiff's evidence, the trial court denied defendant's motion for a directed verdict. Mary Cook, the attending nurse, testified for defendant that she observed plaintiff walking without difficulty on the day of her discharge. At about 9 a.m., Dr. Kelly had informed Cook that plaintiff could not get a ride home until later in the day. Shortly after 10 o'clock, Cook was surprised to see plaintiff walking down the hall on her way out of the hospital. Plaintiff was accompanied by two men who were carrying plaintiff's bags. Plaintiff held the arm of one of the men. Cook, who was on her way to change an IV for a patient, asked if plaintiff needed assistance, and plaintiff replied that she did not need any help. Cook told plaintiff that if she could wait a minute, Cook would be right back. When Cook returned, plaintiff was gone. Cook testified that it was defendant's general policy to walk with the patient to her car. This policy was established to protect both patient and the hospital personnel. Cook did not discuss discharge procedure with plaintiff prior to her leaving because she had not expected plaintiff to leave so early. Ann Parker, an emergency room nurse for defendant, testified for defendant that she treated plaintiff in the emergency room on the night of June 4, approximately 12 hours after plaintiff was discharged. Plaintiff told Parker that she had fallen in the hospital lobby that morning and that she was not alone at the time, but had been accompanied by two of the staff. Plaintiff complained of pain and bleeding, but did not complain of other injuries as a result of the fall. The trial court denied defendant's motion for a directed verdict as to count 2 at the close of all the evidence. When the jury was unable to reach a decision, defendant moved for a judgment, notwithstanding the jury's inability to arrive at a verdict. The trial court stated that it had erred in not previously directing a verdict at the close of plaintiff's evidence. Okay, so I'm going to finish up from the article in the last class, A Legacy of Rainbows. Here we go. What you read to them, it will be magical. I often hear parents say they don't read to their kids because they would rather play video games. If you set rules such as no video games 1 or 2 hours before bedtime, then you won't have to compete with those types of things. Studies have shown that children remember and cherish the times that they've read with family members, along with playing board games with family over playing electronic games. In my household, we have a tradition called high-low. Each evening before everyone goes to bed, we go around the table and share one thing that was the high of the day and one thing that was the low of their day. When we first started doing this, my kids would grumble about having to do it. Now, if we miss a day, they let us know that we missed it. Doing this simply opens up a dialogue and allows each person to share how their day went. Everyone feels special and included, not to mention the memories that we are making. All right. I'm going to read a technical paragraph one time at 120, then I'm going to go to 140, and then at 160. Here we go. Ready? Let me give you a short word list. We've got circuit, breakers, replacement, construction, attention. Here we go. A heavy-duty dump truck needs to be a tough partner in heavy construction jobs. Possible trouble areas need extra attention to help cut down the downtime. The dashboard in the cab is designed so that the gauges and switches can be removed from the front. This gives quick and easy replacement in the field and avoids a trip to the shop. Circuit breakers are mounted next to the steering for easy access. There is no loose wiring behind the dashboard. The wiring has been placed in grooves to the rear of the dashboard. Okay, so now we're going to read this at 140. Here we go. A heavy-duty dump truck needs to be a tough partner in heavy construction jobs. Possible trouble areas need extra attention to help cut the downtime. The dashboard in the cab is designed so that the gauges and switches can be removed from the front. This gives quick and easy replacement in the field and avoids a trip to the shop. Circuit breakers are mounted next to the steering for easy access. There is no loose wiring behind the dashboard. The wiring has been placed in grooves to the rear of the dashboard. Okay, so the last one will be at 160. Here we go. A heavy needs to be a tough partner in heavy construction jobs. Possible trouble areas need extra attention to help cut down the downtime. The dashboard in the cab is designed so that the gauges and switches can be removed from the front. This gives quick and easy replacement in the field and avoids a trip to the shop. Circuit breakers are mounted next to the steering for easy access. There is no loose wiring behind the dashboard. The wiring has been placed in grooves to the rear of the dashboard. Okay. I'm going to read continuation of the Actus Rheas in sexual battery. Okay. All right, and again, some of this is a little disturbing, but again, we have to get used to hearing this, especially if you want to work in court. Okay, here we go. Rather than classifying sexual offenses according to mens rea, as in homicide, harm and threat of harm are the criteria for grading the seriousness of sexual crimes. The victim's age and the relationship of the offender to the victim contribute to the evaluation of harm. Simple criminal penetration or rape is more serious than simple criminal sexual contact, which is sexual touching that the actor knows is offensive to the victim. Both are usually aggravated to more serious penalties if the victim sustains serious bodily injury, is a minor with an older assailant, is incompetent or helpless, is attacked by a stranger or one who has accomplices, is threatened with deadly weapons, or is assaulted in connection with another crime. Also, an aggravated charge is likely if the offender is a parent or otherwise in a position of trust or authority. Incest, sexual conduct between specified family members, regardless of age, is an aggravating factor in some statutes and a separate crime in others. The following cases illustrate some of the problems in sexual crimes. State versus Oritman, Minnesota, 1991, held that a hug by a pastor during a counseling session was not sexual conduct. Evidence of physical force was not necessary to establish constructive force in the rape case of a defendant who falsely identified himself as a police officer to a female motorist and threatened to lock her up before having sexual intercourse with her. Commonwealth versus Carcinola, Massachusetts, 1995. Transmitting HIV to a minor during anal intercourse. Zool versus State of Texas, 1990. And intercourse by an HIV positive man using a condom, regardless of the consent of his female partner. U.S. versus Joseph, NMCMR, were both sufficient for aggravated sexual assault convictions. Megan's Law and Sexually Violent Predator Acts. The 1994 rape and murder of 7-year-old Megan Kanka led to a new law in her home state of New Jersey. Outrage that the killer's previous record of sex offenses against children was unknown in the community shaped the Megan's Law requirement that convicted sex offenders who are released from prison must register their addresses and other identifying information with local law enforcement agencies. The agencies then release that information to the public in the hope that greater vigilance from informed neighbors will keep the offender from attacking again. Failure to register each new address within 10 days of moving is a crime. After 10 years without further offenses, the registrant may request release from the registration requirement. In 1996, a federal version of Megan's Law was passed, mandating a sex offender register in all states, along with a companion law that provides for a federal reporting system accessible to the states. 42 USCA 14072. Some state laws provide for pre-release psychological testing and a hearing to separate those who have been evaluated as high-risk offenders from those who pose a lower risk. Local law enforcement agencies, victims, and victims advocacy groups are notified of the release of low-risk offenders. At high-risk offenders, name, photograph, address, and criminal history are also released to the public and news media. The U.S. Supreme Court has upheld 6 offender registration. Connecticut Department of Public Safety versus Doe, 2003, held that convicted offenders may be forced to register without a separate hearing to determine continuing dangerousness. This decision in Smith versus Doe, 2003, characterized the registration as dissemination of truthful information in furtherance of a legitimate governmental objective, which is not punitive and therefore can be applied to cases that predate the registration law. Because Hawaii's Megan's Law did not provide offenders with notice or the opportunity to challenge their placement on a sex offender registry, it denied their right to due process. The ruling in State versus Bonnie, Hawaii, 2002, led to the amendment of the law and vacated the registration requirement of the defendant convicted of misdemeanor sexual assault for grabbing a 17-year-old girl's body while he was intoxicated. Some states post their sex offender registries on the internet. Megan's laws have survived constitutional challenges in several states because they are intended for community awareness, not punishment. Critics argue that negative public reaction to the registrants is indeed punitive, is based on status rather than conduct, and that the hearings violate the constitutional protection against being tried twice for the same crime, double jeopardy. Others believe the laws are ineffective and exaggerate public anxiety. 19 states have passed laws requiring sex offenders who have served their prison sentences to undergo civil trial to determine their further threat to society. If they are found to be violent sexual predators, offenders may be held at psychiatric hospitals involuntarily and indefinitely. The decision in Sealing versus Young, 2001, established that confinement of sexual predators after a criminal sentence is served, even under conditions that are incompatible with treatment, is a civil matter in the interest of protecting the public from both treatable and untreatable offenders. Only clear and convincing evidence that the defendant is a sexual predator rather than the higher standard of proof beyond a reasonable doubt is necessary for determining the status of a sexually violent offender. Commonwealth versus Maldonado, Pennsylvania, 2003. In Kansas versus Crane, the U.S. Supreme Court ruled that sexual offenders must be shown to have a mental illness that causes a serious lack of self-control before they can be involuntarily committed after serving their prison sentences. Sexual predator commitments deny due process to those identified as sexual predators, according to critics. Although community protection may be part of the justification, without a good faith effort at therapeutic rehabilitation, the entire scheme of civil commitment of sex offenders who have completed their criminal sentences becomes preventative detention. All right, so that concludes. We went way over. Sorry about that, but I wanted to finish that. So that concludes our 140 literary and jury charge. Have a great day.